why don't you tell them again about your book and how they would go about to purchase it and what the exchange would be?
There you go. Excellent. I appreciate it. I'll do this really briefly. The book is called We the Posterity, Voluntary Bondage. It looks at law and government through a view also of Scripture so that we can understand everything that applies about the law by which we can understand our current circumstance. It's on CD. It's on CD because it really does read easily, and it's designed to be printed on 8.5 by 11 sheets, but it's 1,551 pages total.
Wow.
So publishing that in hard copy became difficult. So it's on CD, and the additional advantage to doing it that way is, in addition to keeping costs down, we can trade one disc for another. One of the things I do in this book is blast away at the funny money system. Now, there are wonderful people who have spent pretty much their entire careers discussing and understanding the money systems. But what strikes me as fascinating is that as excellent as their books are, they turn right around. They turn right around and sell their books that blast away at the funny money system in funny money. They say this is tradable for such and such number of dollars, which, of course, is a reference to Federal Reserve notes. I don't like Federal Reserve notes. I think Federal Reserve notes are a direct offense to my God. I do not trade my book in Federal Reserve notes. I trade it for 1 troy ounce fine silver. Guess what? That's the money that we find in Scripture. So it's also the money that's talked about, both in the Articles of Confederation and in particular in the Constitution. If we had an honest money system, if we had an honest system, period, we would be using an honest system of weights and measures.
What type of contracts do we get into that we are unaware of?
The contracts that we're unaware of being contracts largely arise in the taxing mechanisms. We've got unknown agreements with Social Security. We've got unknown agreements with anything with the financial institutions. Banking, savings, retirement, investment, all of these sorts of things. We've got unknown agreements in our land, and this was another thing I was going to get into with the caller about the gun shop, and whether we've actually got an export issue there. If he walks in as a Georgia national and they can only deal with U.S. citizens, then they may have an export restriction to get into, and it's a critical kind of thing to understand. But land, cars, boats, airplanes, just about anything in the way of property that has a title to it will be part of what I call the scam, be part of the hidden agreements.
So just about any time we sign our name, we can be literally signing our rights away or waiving those rights, and we don't even know it.
That's exactly right, and another critical thing there in the signature has to do with how the name is spelled and whether they need a commercial identifying number. Those kinds of things instantly tell us the choice of law, and where we can distinguish correctly the choice of law and where we properly negotiate those deals, then we're not blindly just doing what good Prussians do, which is doing what they're told. When we do what we're told, we've basically given away the farm and are now finding ourselves in a position of having to buy it back.
So, okay, we've kind of identified the problem. What steps can I take to start to undo this? And again, I want to caution my listeners that this may not be easy. There's no one form that you can sign to make all the other bad contracts go away. But, I mean, you know, assuming that I've dedicated myself to liberty and I want to have my own property and I want to live the way I grew up thinking the United States was, what are some of the steps that I can take to make that happen?
The first and foremost step to take is to identify the problem correctly. We've been doing that most of the morning, and that is to distinguish between what we think is the law in operation and what must actually be the law in operation. So the first step really and truly is identifying the problem correctly. Once we understand what the problem is, we're instantly going to know what the solution is. So we then look at each of these problems. We can take a property tax problem. We can take a traffic court problem. We can take a tax problem. Pick your favorite form of tax. They're all different. I call them games. I think about it as games in the game closet. We take out a box. We open up the box. We read the rules to figure out how that game works. And then we understand what we need to do in that area. They're all different. They have some commonalities, but they're all different. And the things to do then are to understand how we got into that particular agreement and then decide whether we can live without it. So this is still kind of generic. The two areas in which I've done most of my studying for the last several years are the income tax system and the land issue. And, for example, in the land issue, we've got to understand what are the details by which we choose the wrong choice of law. There are things like time, place, capacity, medium of exchange, and in that case, property description, all of which can indicate that we want all of this transaction and all of these property interests to be recognized in the Constitution-free maritime commercial zone. If we don't understand the differences, that is the path that we will be led down. When we do understand that time matters and that time is evidence of choice of law, that capacity, medium of exchange, all these things are indicative of the choice of law, then what do? We negotiate that paper. We make sure that that paper says what we want it to say before we sign it. And that's still kind of generic, but this is...
Well, let's talk about medium of exchange.
Okay.
What type of, what are my choices, and what do those choices ultimately give me?
Excellent. The two fundamental choices right now are the funny money system, which exists in the Constitution-free maritime commercial zone, because
we're talking Federal Reserve notes?
There you go, Federal Reserve notes. Under the law of the land, that system is fraud on its face, and we don't have time to get into why. There are not very many people listening that would be surprised to hear that. They could probably teach on the point. So we know that because that exists and because no one is going to jail for it, that there must be a different choice of law in which that funny money is fully legitimate. Okay, when we use Federal Reserve notes, then if we say nothing more, then it can be presumed safely that the choice of law is not the law of the land, but the maritime law that goes along with this other play. So it's an excellent example. If we want law of the land to be presumed, then we need to use an honest system of weights and measures. My favorite is silver. And I sell my book for 1 troy ounce fine silver to introduce the fact that that sort of thing matters, and it matters at the threshold. The minute we establish that choice of law, everything else is different. So, evidence of choice of law, we use silver. We use silver, and we can denominate it in terms of troy ounces. Some people still want to use the term dollar. Dollar is a weight. The Spanish dollar was a weight of silver or a weight of gold, and we can study the statutes we have right now and find that that weight is not defined in the United States Code or in any of the state codes. So we don't have in that place, in the federal zone, we do not have a definition of dollar. but dollars should be fully recognized under the law of the land. If we use that term, then it would be good to include a definition of that term in the agreement itself. Troy ounces, those are uniform enough that might not need an additional definition.
Well, the bad news, I suppose, is that if I use dollars, I'm automatically in this extra constitutional jurisdiction that, seems like Alice in Wonderland. And all I have to do to get out of the system is no longer use Federal Reserve notes. That's a big task, isn't it?
It's a huge task. It's next to impossible. One of the reasons Kennedy was assassinated was to keep that order of quarters from circulating. One of the first things LBJ did was cancel that order of silver quarters that Kennedy had made. And this was at the time of prepping for the transition to take an honest system of weights and measures out of general circulation. When that happened, we changed jurisdiction.
Harmon, yesterday we were talking about citizenship, and there was some information that most people may be unaware of, that there are different types of citizenship, and these forms of citizenship are very important because they establish our legal status. And it sounds like hocus pocus or Alice in Wonderland. Could you outline the difference between a citizen of the United States and a United States citizen?
Sure. The original language, and what we're talking about here, is what some people would consider to be a distinction that has no difference. And the reality is it's exactly this kind of distinction that has all of the difference in the world. As phrased originally, we will find it phrased this way in the document called the Constitution. Citizen of the United States. So the original concept was identified with that phrase. What we see in the statutes now is the phrase United States citizen. And as I may have mentioned yesterday, one of the things that been brought to my attention recently, I just love this. Thomas Jefferson was not a United States citizen. Now, the rest of that is he wasn't a citizen of the United States either, but we'll talk about that sometime later. The point is there is a difference. And the statutory concept is the one that we find in all of the paperwork. People may be aware of the matching puzzles, match this concept in this line with that definition or something in that line, and you draw a line and you match them up. Sometimes kids do this for some of their homework assignments. Okay, what we're doing is matching the phrase in the statute with the documents in which that phrase is used. This is how that document then, in legal terms, would incorporate by reference all the statutes that go along with that term and everything related to it. So, where we find, for example, in a voter's registration document, the term U.S. citizen, we are talking about a different organization, I think of it sometimes in terms of a private club. We're talking about a different organization from that contemplated by the Constitution. Where we find the term U.S. citizen, for example, in a passport application, it is a reference to the statute and everything related to that statute. It is not a reference to the language in the Constitution. Is that the kind of thing you're talking about?
That is precisely what I'm talking about, and I have a passport that is well worn. Every time I go to the airport, the inspection people at security look at my passport, and then they look at me, and they go, well, wow, this is pretty beat up and battered. And so then I tell them, how much I've been traveling and what I was doing in the 2003-2004 time frame, and they usually don't give me any more trouble. But when I got my passport, I noticed a paragraph there that said that this passport was good for United States citizens /nationals.
There we go.
Now, anytime two words are separated by a slash, it means either or. So, I mean, we've just kind of talked about United States citizens, but why would it be important to distinguish between United States citizens and United States nationals?
Excellent. And we talked a little bit about that yesterday. Let's do that again. There is a world of difference between nationality and citizenship. Nationality is a concept that is attached to us as a matter of law, and in that sense, we don't really have a lot of control over it. It's not 100% that way. We do have control over nationality, but that takes a lot more effort than the citizenship. Nationality is something that happens by operation of law. There are a couple of different legal theories. Just solely is probably the Texanized pronunciation of that, but that's the rule that says nationality is a byproduct of where the person is born. Now, it's a reference to the body politic, and let's just use an example. Ancient Israel didn't have a specific place on the planet to call home. They were roaming around for 40 years. Were those people Israel nationals or not? Well, of course they were. They were born into the body politic of Israel. Okay. Now, what if they were born in Egypt? That would make them Egyptian. What if they were born in Canaan? That would make them Canaanite. And we go on and on like this. But at the base, that body politic, wherever they were at the time, is the same body politic. So what we're identifying is the break, and I guess we'll come back.
Bob from Texas. Good morning, sir. Thanks for joining us.
Good morning. Am I on the air?
You are on the air.
Good morning, Harmon.
Good morning. How are things where you are?
Perfect.
Great. Appreciate the call.
Well, I had a question that I've never discussed with you before, and it relates to property that was purchased in America prior to the introduction of the fiat currency that we have today. Hypothetically, what if a grandparent had purchased a piece of property and paid for it in gold or silver, or gold or silver notes at that time? How was that property placed onto the tax rolls?
Through a couple of things, and we're probably jumping way ahead, but let's go ahead and answer this directly, and I appreciate the question. To understand land ownership today is to understand so much about our problem, so I really appreciate the question. The land that you're talking about would have been held in fee simple, and the title would have been superior to all in the world, and that's exactly what we don't have these days. How did that change? Let me give you an example and then come back specifically to this one. There's a community here in Dallas that is the original community. It's called Highland Park. It's its own separate place, and the people wanted to put a building in the backyard of their property. The people that were going to do the work said, we can't do it until you get a permit. Okay, so they tried to get a permit, said, we cannot give you a permit. Your property isn't registered. So, rather than realizing that they have no obligation to that system whatsoever and could have gotten a contractor to build whatever kind of building they wanted, they transacted that property off the land and into the Constitution-free maritime commercial zone by registering it. They totally went backwards on the deal. Totally went backwards. I
am ill.
Yes, this is. If you understand the analogy, you can get physically moved by this and not in a positive direction. So what happened? They got their permit, and now their property is subject to all of the things that kind of property is subject to. The most recent nationally recognized disaster, of course, is the Kello v. City of New London opinion, where the property had been in the family for 100-something years, and they lost it to eminent domain. How does this happen? Transferring the property into the Constitution-free maritime commercial zone. So your grandparents' property traded under the correct medium of exchange to identify the choice of law, being the law of the land, is transferred into the Constitution-free maritime commercial zone identified in the state statutes by the phrase, this state, by registering it. At some point in there, they did, or someone did, someone inheriting the property, did what they were told to do rather than what they needed to do. When we do what we're told to do, we're into the scams.
I understand exactly what you're saying, and I appreciate your response. I had a comment that I wanted to make related to, I looked up the word commerce in the dictionary.
What'd you
and the
find?
word commerce has a number of definitions, and one of them is sexual intercourse. I was kind of shocked to see that, and then I thought about it, and I wondered, since they send a copy of our birth certificate to the Department of Commerce from the hospital or from the county where you're registered, maybe there's more to it than I had originally perceived.
Well, in a sense, I think about that, and of course my favorite agency of all of them is Internal Revenue Service. And if we're talking about commerce, the way you've identified it, service is what happens when the bull is introduced to the cow.
Yeah. Well,
okay.
I believe we've all been serviced.
Yeah, exactly. And that's what I'm laughing about. If you're going to go that definition on commerce, yeah, we've all been commerced.
Well, I really appreciate talking to you this morning, gentlemen, and I'll get off the line and let you talk to somebody else.
Really appreciate the call.
Thank you, Bob.
Thank you.
I appreciate the insightful questions. And Harmon, I can't tell you how heartbroken I am to find out that somebody owned their property in a allodial title and then gave it away by getting it registered.
Isn't that amazing?
Education is expensive, but ignorance is even more expensive.
Right.
So I preach that most of what our government does is unconstitutional. And, I mean, somewhere along the line we had to get off track. And I'm wondering if that happened in 1973 when this U.S. Senate, the upper house of Congress, wrote a report that surprisingly indicates that we are and have been in a state of national emergency since 1933. The first emergency was by FDR for the Great Depression. The next one was by Truman for the police action in Korea. And then there were two more states of national emergency declared by Richard Nixon while we were in Vietnam. And those four states of national emergency still exist. Is that a point in our history when things kind of took a turn for the worse?
It's evidence of a problem that if we can march backwards through time, we'll end up to where this started. But yes, it's evidence that we're in a condition that's something other than what we're taught in high school about what is the basis for government. So it's evidence of it. And the national emergency, let's talk about what that really is talking about. What they're saying there is we have no money. And here I use the capital M. We have no money. Okay? No constitutional money. We are in an emergency. All of these emergencies exist and will continue to justify the Constitution-free maritime commercial zone. Why? Because you don't need money there. You don't need money there. So it's an emergency. They've got great cover stories. It's not really an emergency. It's just the indicator that we're not dealing with the law of the land, predominantly because we don't have money in circulation.
Okay, so if it wasn't 1973, that was really just kind of documenting the problems that
there
we
you
have.
go. It's evidence of it. Exactly right.
Is there anything in 1968 that it got us off track?
Well, in 68, we're seeing then what happens in the statutes to fulfill what one of the key problems was that got Kennedy killed. Kennedy ordered a bunch of silver quarters. Now, they weren't troy ounce .999 fine. It was the 70% or the 90%, but you may remember quarters before sandwich quarters. Okay, that keeps an honest system of weights and measures in circulation. In 1968, it wasn't exactly then, but there for the next few years, probably up until 73, in fact, the organizations called states were dealing with a body of statutes called the Uniform Commercial Code. And what the Uniform Commercial Code does at that time is confirm at the state level we don't have a definition of dollar anymore. We're going off an honest money system into this place, into this separate place, into the Constitution-free maritime commercial zone. And so we're going to put all the statutes in place to make that possible. So again, it's evidence of the problem. You're exactly right. But you got another date ahead of that?
Well, you know, the 1968 was also when they passed the 1968 gun control law and put into statutes all of the many of the unconstitutional violations of our right to keep and bear arms. That was a bad year. How about 1948?
Okay. Again, we've got more evidence. 48 is significant for this. I'll just mention it really briefly. 48 is the year in which the entity called United States of America made its debut. The UN came in around 45, and about 3 years later we get the United States of America. And I don't mention that in the same breath accidentally. In 1948, we have a lot of the transition that we see in Title 28 about the creation of a United States District Court system. What was it ahead of that? A District Court of the United States system. Now, a lot of people say, oh, there's a difference and therefore the new is bad. No, there's a difference and therefore it's just different. We've changed choice of law. We've changed a lot of things. But anyway, 48 is the debut of the entity called United States of America. Before then, it was United States. And we transition from District Courts of the United States to United States District Courts. Again, it's evidence. It's evidence of the problem. Let's go back in history a little more.
Well, I want to focus on that just a little bit more because I don't know that, you know, if we just kind of gloss over it, I don't think our listeners will understand the importance. So in 45, there was a creation called the United Nations.
Correct.
And the United Nations has a Declaration of Universal Rights, which if you read it they are really privileges granted by some world body. So, I mean, I reject the United Nations out of hand. But you say that 3 years later, after the United Nations, we created something called the United States
of America.
The United States of America.
Correct.
Okay.
Separate entity. And I'll just be very overt about it so as not to be too subtle. It is my understanding that United States of America is a subsidiary of the commercial entity called United Nations.
Wow. So if the United Nations is bad and the United States of America is a commercial entity, we're talking a corporation that was invented in 1948, subsidiary to the United Nations, then the United States of America, as wonderful as it sounds, is probably kind of a bad thing.
It's kind of a bad thing. It's a game name. It's just more of the game name. For example, Patriot Act. They're supposed to be pro-patriot. What does it do? It destroys rights. At least it purports to. So, yeah, it's a game name.
So very much like the difference between, quote, citizen of the United States, end quote, and, quote, United States citizen. Now,
Amen.
They sound alike in conversation, and most people give them short shrift. They figure, well, you know, it's just a different way to say it, and there is no real significance, when, in fact, that is the significant thing.
Amen.
They are playing this word game. We are in an ideological war. And, I mean, this is more important than high school English class. I mean, you know, a dangling participle I can forgive. But to play with these words, which literally are referred to as words of art, They are designed to confuse you. At least if you go to a county fair and they've got the walnut shells there, that you pretty much know that this is going to be some sort of a con. But
the shell game is one of the most perfect analogies you can raise in this context. It's excellent.
Yeah. So they not only have confused us with United States citizen versus citizen of the United States, now they are confusing us in 1948 with United States and United States of America. And
correct.
Those are two different entities legally.
Correct. That's exactly right. And just to throw this in this context, this national ID thing has everything to do with citizenship under the UN and nothing to do with anything else.
I will never, ever take an RFID chip. Man, oh man. You are listening to Michael Badnarik and Harmon Taylor here on We the People Radio Network. And, my co-host this morning is Harmon Taylor. You were a bar-certified attorney, and you've left that profession. You're no longer exercising that certificate. Could you give us a little reason why?
Sure, and I appreciate the question. It comes down to the concept of conflict of interest, and if we apply the ethical code properly, then I developed a conflict of interest. We talked yesterday about the Terre Haute litigation a little bit. That totally changed my world. That was in 2001. By 2003, I had fully satisfied myself that that which is marketed to us is very, very different from the reality. What I had been asked to take an oath to was to support the rules and policies and even the mere existence of a system that's set up to scam me, my family, friends, and neighbors across this nation. And I cannot lend my name to that. And it just comes down to that. So, as I was fully satisfied in my own mind, didn't rush into it, obviously. It took me a couple of years to work through that. But as I satisfied myself fully that there was at the base an oath to support scams, I could no longer do that. That's what's in the letter. The rest of it has to do with Scripture. We're not going to get into a Sunday school lesson here, but I'll just mention very briefly. The Lord raises up beasts to devour and destroy the rebellious. The system we have is a beast system, and I have no intention of wishing well the beast by lending it my name. It's not going to do that. So, on the legal side, it's a conflict of interest. How do you solve a conflict of interest? You withdraw from the representation. Okay, I'm representing the bar system and the judicial system that do not stand for the principles that many still think they do. It's not set up on constitutional principles. It is not set up on the law of the land, and I'm not going to lend my name to it. Scripturally, I'm supporting the wrong side there, and not going to do that either. So that's why I resigned. I was effective May of 2003.
Well, I welcome you to the program, and I think that's
pleasure to be here.
I think it indicates that you are a man of integrity. And we had someone call in and then drop off the line. If you'd like to call back, we'd be happy to go to your call. I apologize if I can't answer your call immediately. I like to keep the concepts flowing smoothly here. So we were talking about when we got off track. And we were talking about 1948 when they invented something called the United States of America, which is a corporate subsidiary of the United Nations.
Likely. I don't have anything that affirmatively confirms that, but all of the behavior fully confirms this theory. So we just keep that in mind. What we do know for sure is they changed the judicial system, and that's in the statutes.
I have a real heartburn for the man who was president, elected in 1932, Franklin Delano Roosevelt, and I have to be very careful because whenever I start talking about Mr. Roosevelt, my language changes to reflect my mood.
I'll just mention here, sorry to interrupt, I did not understand the concept of hatred until I understood what happened at Pearl Harbor and what happened with the gold system. And, of course, I worked through that. But I never understood really what hatred was until I understood about that man. So I understand the language. If you slip, believe me, you're in wonderful company.
Oh, I've promised myself that before I die, I'm going to go to Hyde Park, New York, and I'm going to filter a six-pack of beer onto FDR's grave.
We may just have to have a party.
Well, I've had several people want to go with me, and I've had one person that wanted to film that. And,
put it on YouTube.
I'm not sure that that's the film I want of me on YouTube, but I agree with you. FDR was not my favorite person, and
we can say it that way.
And very much because of what happened in 1933. Can you talk about 1933 for a while?
Sure. I'm expecting that what we're talking about here is the gold confiscation, and the key thing to identify there is that the people who had their property confiscated were those who had identified themselves as U.S. citizens here under at that time, the 14th Amendment. So those who were not U.S. citizens would have been victims of theft. Those who were U.S. citizens had, by that political affiliation, adopted that policy. But what happened there was gold confiscation, and again, what we're talking about when we are looking at removal of money, capital M money, from general circulation, be it the hard metal, coins, bars, that sort of thing, or you'd mentioned, or I guess Bob mentioned the gold and silver certificates regarding land. That's perfectly good. It's evidence of an asset. So where we're talking about removal of that from general circulation, what we are seeing is evidence of a change that has already happened. If we had a law of the land-based system, removing gold or silver from circulation would be a crime. It would be a crime. It would also be interference with contracts, because all the agreements would be based on what? That choice of law. So we already have in place by 33 a choice of law difference by which it is then not a criminal act to go into somebody's bank deposit, safe deposit box, bank's safe deposit box, go into the property stored at the bank and take it. So, yeah.
That's theft.
It is theft if we're under the law of the land system. That's exactly right.
Now, correct me if I'm wrong. The purpose of the Constitution, ostensibly, would be to protect our lives, our liberty, and our private property. And every member of government, at the county, state, or federal level, they all theoretically take an oath of office to protect and defend the Constitution. Now, we don't expect them to go down to the National Archive once a month and stand in front of a piece of parchment, do they? They're not protecting the actual Constitution. They're supposed to be protecting the ideals, the lives, liberty, and private property of those of us who live here in what is, called the United States. So, gold is property. FDR was president of the United States, who presumably took an oath to protect and defend our property, and then with House Joint Resolution, and you can go to the Internet and search for HJR 192. HJR space 192, and you'll find all sorts of references to it. But House Joint Resolution 192 basically made gold illegal. If you owned gold, you were, quote, hoarding it, and you were supposed to turn in gold. I mean, how could the president who had taken that oath tell you that you're not allowed to own property if it is, yellow and shiny?
Let's look at three different aspects of your question, and the break may be upon us before we finish this, but I'll hurry. What's he taking an oath to? We make a word game out of protecting the document itself. I will tell you that's not a word game. When we get into the occultic mindset and the double entendre way of thinking and the words that are used, that's the kind of thing that may very well go to mind. So it's physical preservation being secured. They can protect and defend it. They just turn that over to the archives. Legally, the Constitution of what they're talking about will be found in Titles 1 to 5 of the United States Code. Let's also go to another thing, HJR. When we read Article 1 and we read the process for a bill, what is the process by which language becomes law? In this case, law of the United States. That process is the process of a bill. A process of a bill. A bill and only a bill will ever become law of the United States. What does a House Joint Resolution become? Nothing. What's a resolution for? Internal operating procedures. Internal operating procedures. The only other reason to do a resolution is to make a public statement of opinion. We're going to congratulate so-and-so. We're going to recognize this as Groundhog Day, this sort of thing. A House Joint Resolution is never admissible evidence of law. And as regards property and money, you see, we're not just talking about property. We're talking about what constitutes money. Money is in and of itself not a legal question, but a political question. Signing on as a U.S. citizen as of that administration means we're confirming that we do not recognize gold or silver. Well, silver was still around. We're not recognizing gold as money. It's a political statement. If it's not money, who needs it? So they found a way to take it.
Now, I am stunned, appalled, and shocked that FDR could, basically make those statements publicly, saying that you have to turn in your gold. But what stuns me, shocks me, and appalls me even more is that American people would do that.
Exactly.
It's like, what planet were you born on? I mean, don't you send me $25 in a self-addressed stamped envelope, and I'll teach you how to spot a con man. It's like, this is insane. I can't imagine sending my gold to the president just because, he said so. And that, as far as I'm concerned, is a very important, very key point in our history, because the Constitution, which is based in common law, and that's what we've talked about in the past, is common law jurisdiction. Common law is based on property. So in your case, you have a CD available, and that's a piece of property, and you are willing to exchange that piece of property for someone else's property, assuming that it's an ounce of, 999 fine silver.
Correct.
And so you exchange property for property. That, in my understanding, is a quid pro quo transaction, and that it automatically falls under common law jurisdiction. And so if you take real money away and use colorable money, then you have to invent colorable law to adjudicate it. Colin, good morning. Thanks for joining us this morning.
Good morning. How are you guys?
I'm wonderful. And you?
Oh, I can't complain. It's a great day. But I do have a question. I'm asking about his bar license. And just to give you a background, I'm getting into law myself. I'm finishing my bachelor's degree and wanted to go to law school because over the years I've found all these problems, especially with the tax system, was the little hick getting me going. And what I want to find out is, obviously, we have a right to counsel. It gives the Constitution or the Bill of Rights gives us that. So what can we do
let me
without
interrupt you.
having...
Colin, let me just interrupt you. Words are very important. The Bill of Rights doesn't give you anything. You are born with your rights, and the Bill of Rights, and specifically the Sixth Amendment, simply enumerates your rights. And that's a really important distinction. That's a really important distinction. I hate to interrupt you, but the Bill of Rights doesn't give you anything. If it did, those would be privileges, and then the presumption is that the government and the Bill of Rights could take it away. So you have the right
to counsel. Yes, we have a right to counsel. So obviously, how can, if I'm going to be an attorney and I get a bar license or whatever, how can I properly represent or help somebody without that conflict of interest? Obviously, without having a bar license, how can this be changed to be able to still represent somebody and give them that those abilities?
The question is excellent. I really appreciate the call. Let's start at the foundation of the matter and understand what it is that can be licensed at all. What is licensed is commercial activity. The state of emergency that we were talking about relative to that Senate document in 1973 addresses that place where all of this commercial activity exists that can be licensed. So, applying that, what we have in your question is a mixing and matching of law of two very different places. We're saying if we're in Great Britain, why are we subject to the law of Germany? And the answer is, if we were in Great Britain, we would not be subject to the law of Germany. Therefore, if we are subject to the law of Germany, that's where we must be. Why do we have a license to do this thing called practice of law? Practice of law is commercial activity relative to the Constitution-free maritime commercial zone. There is no such thing as practice of law under the law of the land. We read the concept about assistance of counsel, as Michael's identified, that's a Sixth Amendment concept. We read that there and we understand that that is relative to the law of the land. Yes, so if we had a system based on the law of the land, there would be no such thing as a license to practice law, because we are not dealing with a system that derives its authority from the law of the land. We are then dealing with a system that may regulate commerce, and in the regulation of commerce, they may fully say, you must be a member of this club in order to do this commercial activity. The conflict of interest then really isn't at the level of being an attorney and having the then authority or license or privilege of going into their courts and asserting the client's position in that system. The conflict of interest actually starts a lot earlier than that. Do we even want to be a member of that church? So, anyway, let me just say this. What I'm doing now would have been impossible if I had not taken the route I had taken. My blindness about all of that was not accidental. We can look in John chapter 8 and find out about the guy born blind. I was blind to all of this until I had already been practicing several years with the license. If law is a calling to you, do it their way. Go through the law school program, get through the bar exam, be licensed, go out, get all the experience in whatever area you want, and then reevaluate where you are. Why do I say that? One can start off from scratch doing the kinds of things that might help, but you're dealing without a lot of experience with the system, with people, especially in the court system. This is what I'm talking about mainly. who have absolutely no exposure to it. So what I'm suggesting is try to avoid being in the circumstance of the blind leading the blind. You will have a conflict. You will take an oath to support the beast, and that's exactly what that is. If you want to make a contribution in that area, may the Lord forgive us, but go ahead and do that. Why? Because then you'll see from experience how it really works. And
I want to thank Colin for his question, and before we go to the commercial break, I want to go to Bob in West Virginia. Good morning, Bob.
Good morning, Michael. Good morning, Harmon.
Good morning.
I wanted to jump backwards here for a second on the property issue. Because you register your property, it puts it into commerce.
Correct.
Is there a way to take your property out of commerce?
Yes, and amen. Yes, there is. I don't know the exact time we've got here, but I'll make this short. There's the transaction itself, and then there's the registration of that transaction. What we do going the wrong way is animate the wrong capacity, the wrong time, the wrong place, typically the wrong property description. We use the wrong medium of exchange. We make the wrong choice of law. And we file that statement publicly. By doing that, we create interests in that property that actually are trust interests. It's those extra interests that are basically the basis for what we call property taxes. Okay, what then is the solution? We do another transaction, and in that transaction, we get the capacity correct. We do the time indication correct. We do the place indication correctly. We do the property description correctly. We do the choice of law correctly. We identify the proper medium of exchange. And then if we really want to make the political point, we'll add in some deed restrictions that talk about hypothecation of this property and put some restrictions on that. So in general, your question is, can we fix this? The answer is yes. We just got to understand how we got into it.
And Harmon, we're working our way backwards through history, and I think I have emotionally recovered a little bit from Franklin Delano Roosevelt and what he did in 1933.
It's an effort. Every time the name comes up, it's an effort to get through that.
I really do. I have to just take a deep breath. The year 1913 was not a good year for liberty. What happened in 1913? A lot of different things.
Yeah, we got a couple of the main things. That's about the time we hear of this so-called 16th Amendment. And it's also the time we hear about this thing called the Federal Reserve Act. Let's look at the bank thing first. If we're dealing with an honest system, and where the Constitution says there shall be this sort of medium of exchange, then it's not terribly offensive to say, okay, all you people out there that are in the business of coining money, here's the standards to use. And if we catch you not doing this way, we're going to charge you and put you in jail. What we have with the Federal Reserve Act is something very different. It purports to create an entity that itself creates this thing called money. So it is the appearance of transfer of the entire mechanism that a Treasury Department should manage over to a private entity. And very, very important to understand is that the Federal Reserve System is not government. It is a private system.
It has the word federal in it.
Yeah.
It's the Federal Reserve, so that's got to be government, right?
Let's talk about the word federal real quick. Federal means federal. Federal doesn't mean national, and it most certainly doesn't mean constitutional. What does it mean? Federal. At the level at which we think about a state, federal means by compact or by treaty. At the level of the individual, federal means by private obligation. So it's a perfectly applicable term. Federal government operates by private obligation. Federal Reserve System operates by private obligation.
And
So
Federal Express is not a part of the U.S. Postal Service. It is not part of the government just because it has the word federal in it.
Correct. And we can go through the yellow pages or the white pages and find entities that have nothing to do with government that start with the United States. It's the exact same thing.
And Article 1, Section 10 of the Constitution declares the states shall use no other thing but gold and silver coin as tender in payment of debt. 185 says that Congress has the power and responsibility to coin money, and they certainly do not have the authority within the Constitution to give that responsibility to a private entity which is going to start printing fiat paper. So the Federal Reserve Act of 1913 is purely, totally, 100%, unequivocally unconstitutional. It is just anathema. And Ron Paul, who's running for president, would like to abolish the Federal Reserve, and I encourage you to go to ronpaul2008.com to find out more. So we've got, in 1913, they gave us the 16th Amendment. They gave us the IRS, everyone's favorite organization. They gave us the Federal Reserve Act. Oh, and they also presumably passed or ratified the 17th Amendment, which turns the Senate into a small House of Representatives. Whereas the senators used to be elected by the state legislatures, now they were elected by we the people. So 1913 was not a good year for liberty. So we can say conclusively then that 1913 is the year that all this really started, or is it earlier than that?
It's earlier than that. We've got evidence, in particular, the 17th Amendment thing, where it totally changes, flips on its ear, the entire concept of the basis of the authority of the Senate, which is the voice of the states, and they gut that. Something has changed prior to 1913 to justify that change. So you got a date ahead of that?
When was that? What date was that?
The 17th Amendment?
No, the 17th Amendment was 1913, but you said there's a date before 1913. We got to go back before then?
Yep. We can go back through several dates. We can look at 1860 for Civil War. Some people say we lost it there when the Senate dismissed Cena die and that they've never come back. We can go back to 1850s for funny money. We can go back to 1824.
Well, let's look at 1860. Who was president in 1860? Do you remember?
There we go. One of your favorite people.
Oh, Abraham Lincoln. Now, when I was in kindergarten, I went to school, and for President's Day, I had to do an outline, a little silhouette of Lincoln's profile, and pasted it on another piece of paper. And apparently, I came home running home, all excited because I had a president. I learned about President Abraham Lincoln, and I was so excited. Now, I'm not so excited. He came up with this concept of war powers, the idea that in times of national emergency, we need to eliminate the Constitution. We're going to put the Constitution on hold, and we're going to fight this thing that we refer to as the Civil War. And then, supposedly, after the Civil War, the government is going to give back your rights? Let's talk about that. Why should they take the rights away in the first place? What gives President Abraham Lincoln the authority to suspend the Constitution for any reason?
Right. Well, it's not funny, but it's funny. Here's the concept. Here's where that line of thought takes us. I am the president. I have authority because of this document over here that creates this office. I am still the president, even though I'm telling you that document by which I derive my authority has no authority. I mean, it's just nuts. It's nuts on its face. You can't hold office by one authority and simultaneously say that the document from which that authority comes doesn't exist. So it's just funny. You can't do that. Now, if what he's confessing is that his authority never had anything to do with the Constitution in the first place, okay. Now the Constitution is irrelevant generally. But if he stands on the document, you know, it's just funny. He stands on the document, says, "This is where my authority comes from," and turns right around in the exact same breath and says, "But that authority doesn't exist." I'd like for someone to explain what he thinks is the basis for his authority. You know,
we got about 30
seconds
left. We got about 30 seconds left before the commercial. What happened in 1850? You said they started funny money?
Yeah, we start to see games with the money in 1850. We start to see games with the money, and we track that through, and we find that it takes about 10 years for certain people to say, "No, we got this whole thing started not to go there, and if you're going to go there again, we're out of here." And so it was actually the funny money deal, not slavery, but the money issue that is the fundamental philosophical basis for the War of Northern Aggression. Of course, I'm in the South, so I don't call it a civil war. I call it the War of Northern Aggression. But it's money.
Our teachers lied to us. They lied. My name is Michael Badnarik. Harmon Taylor is my co-host. Lighting the fires of liberty is what we're doing, and we'll continue soon. Quince, good morning, sir.
Good morning. I really enjoyed the topic. This is just really great how you're peeling back the layers of history to open this up so people can see where this Alice in Wonderland operational administrative government emanated from in the first place, how we got there. I enjoy you touching on this topic and educating the public on it. And it just it enraged me so much.
Yeah,
it
helps
people
it helps people to understand that this doesn't happen just overnight. You know, when they realize how far back it goes, they realize that, most of what the government does can and is unconstitutional because they've been sabotaging it for, at least 150 years so far. So,
but it really helps for people to understand the mechanics of where it happened, why it happened. You know, was there any logic behind it? What was the mission behind it? And when they understand that, they can see it's not just a natural occurrence of, progressive government just evolving. It is put in place for various reasons, and people have a hard time grasping that. So I won't stay on the line any further, but just wanted to compliment you on the subject matter today. And anticipating Firearms Friday, let everybody know that Wolf ammo burns dirty in your 1911, folks. So be aware of that. It'll jam up your 1911.
Well, I clean it every time I use it, but thank you.
Yeah, if you're using Wolf, clean every time you finish.
Yeah, I do that regardless of what type of ammo I use.
Okay, let's get practice anyway.
Yeah, so we've got 7 minutes left or less. So we've gotten back to 1860, 1850.
Right.
So that's got to be like the start. It doesn't go back earlier than that, does it?
We've got a couple more to go through, and I can zoom through them real quickly if that would help.
That would certainly help.
In 1824, we find evidence the first time of a popular election for this office called president. Why didn't it start at the beginning? Why does popular vote for president not start at the beginning? Why is the first time that happened in 1824? And in 1824, we're not talking about computers and telephones and airplanes. So they had to have started that even before then to do the popular vote. We do not find anything about popular vote in Article 2. It is a non-constitutional process. Let's go back a little earlier. 1816. We might remember the War of 1812. What was that over? They refused to restart or recontinue the First Bank of the United States. So in 1816, we get the beginning of the Second Bank of the United States. And all I want to mention there is we can look in the Constitution and we can see a necessary and proper clause. What's necessary and proper? What may Congress do that's not specifically identified? Law. They may create law that's necessary and proper. Why, then, are they creating commercial entities? So when we see they're creating commercial entities in 1816, and we go back further to the First Bank of the United States, what gives? From whence comes the authority to create a commercial? It's not law. The bank isn't law. It's a commercial entity. They're incorporating entities, from whence comes that authority. So where do we go? We go all the way back to the beginning, and this is a very, very difficult, bitter pill to swallow. It's even difficult to talk about. The fundamental problem starts at the beginning. What we have from the Declaration, and there's history here, I'll just zoom through it, is the declaration of an independent body politic, and in the Declaration we also see Jefferson pen that the legislative power cannot be annihilated, therefore it vests in a group of people called the people at large. The form of government created at that point, it would happen by law whether Jefferson recorded it that way or not, is called a democracy. A democracy has a particular form of making law. Today it's most popularly known as Robert's Rules of Order. There's a procedure there. Bottom line, that procedure at the national level and even at the state level, we have the same issue, requires participation by all who have suffrage for there to be law in a democracy. And we see this in Athens. The people have to participate, not their representatives, not things called states, but the people directly. Fundamentally and procedurally, and there's one side of the problem, is the procedural side, the procedure was never satisfied. We as a nation never activated the democratic lawmaking process. Substantively, we've talked at the beginning about citizen of the United States versus U.S. citizen, and I mentioned that the statement is very correct. Jefferson was never a U.S. citizen. I also said Jefferson was never a citizen of the United States. How do we know? The term was never defined. The only place it can be defined is in the Constitution, and all of that discussion comes up in the 14th Amendment discussions. The only time this really matters is with the office of president, but in that office there must be a citizen of the United States or no one is eligible. Where that term is not defined in the Constitution, it just simply isn't defined. How do we know? Well, we'd say a judge could supply it. Fine. Where are we going to get the judge? First, there has to be a president, and then there has to be a nomination and appointment process. Where there is no president because no one's qualified, we get no judge to tell us. So what we learn from the 14th Amendment discussion is that we now finally, from some point of view, at least have an attempt to define citizen of the United States. Fundamentally then, and to wrap up the origin of the problem, and I had to go through this to understand what the Seventh Circuit taught me in the Terre Haute litigation. Okay, we don't have authority now. Where did it go wrong? And the answer is, where did it start? Procedurally, we as a nation never activated the democratic lawmaking process, and substantively, even if we had, we never defined the term citizen of the United States. What happened was the creation of yet another commercial enterprise. Commercial entities may fully create other commercial entities. Take that back forward then. The commercial entity is not operating necessarily under the law of the land. It pretty much can create its own place. Ultimately, it did, formally and officially, when they got rid of all the honest system of weights and measures. But all along, it was always commercial.
You got 45 seconds.
Acting commercially, and our citizenship is with a commercial enterprise, not a constitutional form of government.
So basically, the Constitution never legally completely existed.
Correct. It's always recognized as a compact, and in that fashion it set aside the Articles of Confederation, but it was never admissible evidence of law.
So our founding fathers maybe not have been on our side after all. And that's a bitter, bitter pill to swallow.
It's a bitter pill to swallow. Most of them were. There were a few agents provocateur, and the agents provocateur prevailed. They represented the commercial interest in Great Britain.